Okay, so the last topic this morning that we're going to talk about as far as presentations is the changes in the workers' compensation laws. And those went into effect July 1 of this year. So now we are in the phase where new injuries that happen fall under these new rules. So some of you, if you were at State SHRM this year, you might have heard me speak on this. So I'm going to try and just recap quickly what those changes are and how you should approach things differently due to these changes. So any new injury reports that you get now that happened after July 1, 2017 are going to fall under these new rules. So a couple of things. Intoxication. If an employee is intoxicated on the job and that led to the injury, that's a defense to workers' compensation, so it's not a compensable injury if they got injured because they were intoxicated. Under the old rule, the employer had the burden to show that the person was intoxicated and that the intoxication caused the injury. Under these new changes, it says that if it's shown that they were intoxicated by test results, then it is assumed that the injury happened because of that intoxication. So it shifts the burden to the employee to come forward and say, well, yeah, maybe I was intoxicated, but that's not why the injury happened, which is a bad position for that employee to be in. So this is good. In all the years that I've been doing work comp, this doesn't come up very often, but I have had it come up. And some of you have heard the story where I had a case where an employee had climbed up onto the roof. He was a roofer, had fallen off the roof and had severe injuries. Well, it turned out he got to the hospital and his blood alcohol level was like 0.34 or something. I'm like, how the heck did he get on the roof in the first place? But so it's pretty rare, but it does come up. And intoxication is not only alcohol, it can be positive drug tests. So narcotics, depressants, stimulants, other types of drugs, and it can be illegal use of prescription drugs as well. So once you've established that through a test, then it's presumed that it caused the injury, and that serves as a defense to compensability. Notice of injury, an employee has an obligation to give notice to the employer of the injury within 90 days after that injury. So even though you have policies in place that say you've got 24 hours to report an injury to us, under the statute they do have 90 days to do that. But they have to do it within 90 days of when they knew of the injury. So under the old rule, there were 3 categories that they had to know: that they had an injury, that it was serious, and that it was likely related to the employment. Under the new rule, it eliminates that they know it's serious. They just have to know they have a condition or an injury of some kind, and they don't have to know that it's serious or it's likely going to be permanent, just that they have it and that it might be work-related. And that starts that 90 days running as far as giving you notice. And I will say the 90-day notice rarely works as a defense in cases. I've tried to bring it up, but it's there, and it is something that we do raise if it seems appropriate in a case. Another issue is suitable work. So if an employee is injured and has restrictions, you try and bring them back to work if you can, but the work that you offer them, the light duty work that you offer them, has to be considered suitable work. So it has to fit within their restrictions. But there have also been a number of cases in recent years about whether it's suitable if you make them travel to a different place in order to do the work. So for an employee who travels more than 50%, this is the new rule, mind you, if an employee travels more than 50% of the time, say a truck driver or on-the-road salesman, then it's suitable work if it's at that employer's principal place of business, so if it's at your headquarters, or if it's a place where the employee has previously worked. So this came up because of truck driver cases. So you have a truck driver who lives in Georgia, but they work for a company out of Des Moines, and they have restrictions, and the company says, you can do light duty here in headquarters. And there were some cases over the years that said, no, that's not reasonable, that's not suitable work. But this is a change to that, and it says if it's your headquarters and you're offering them work, it's considered suitable work. Why does that matter? Because if you offer them suitable work and they refuse it and say, you know what, I'm kind of liking staying at home instead, then you can suspend their benefits, okay? But it's important that if you're offering them suitable work, that you communicate that to them in writing, and then that the details of it, this is where you're going to be working, we'll pay for lodging, we'll pay for whatever. And then the employee has to respond in writing if they want to say, no, that's not suitable because it's too far for me to travel, or whatever it might be. So they have to respond back in writing in order to preserve that. Okay, the biggest thing from my perspective that came out of this new legislation is the change in shoulder cases. So for the last several years, I've had tons of shoulder cases, and in the past, they've been considered a body as a whole injury. What that means is it's not a scheduled member injury. It means that the commission takes into account the effect of that injury on their overall earning capacity. So rather than saying you have a 10% impairment of the arm is worth 250 weeks, so you get 25 weeks of benefits, which is just a strict mathematical formula that you do for a scheduled member injury. A body as a whole injury looks at whether or not you are now unable to do 50% of the jobs that you would have done before because of this injury. So you would get 50% award rather than a 10%. So what it has done is it has made shoulders far more expensive as far as claims in the past. So for example, I had an electrician who had to work overhead a lot. He had a shoulder injury. He was in his early 40s, and since it was considered a body as a whole, they did an evaluation of what impact this had on his ability to earn a living in his chosen field that he'd been doing for the last 20 years. And they said he can't go back to being an electrician anymore. So they awarded him a large award, like 70%, because he can't go back to work anymore. Now, what this new rule is going to do, it's going to say, no, it's strictly based on a percentage. It's not. I'll go back and say the other risk is with the shoulder being a body as a whole, you could also get a permanent total award, okay? And a permanent total award means they get weekly benefits for the rest of their life, and you pay all of their medical bills, okay? So those became very expensive cases. So under the new rule, if somebody has a shoulder injury now, there's a set number of weeks that it's worth, and it's based only on the impairment rating and not an industrial disability. So what does that mean? That means they have a shoulder case, and they go, and the doctor says, okay, you're all done treating, you've reached your maximum medical improvement, you have a 10% impairment to your shoulder. So a shoulder's worth 400 weeks, you do the math, you pay them 40 weeks of benefits, you're done, okay? This is hugely different than it has been the last several years. It's going to control the number of shoulder cases that are filed with the commission. It's going to control the cost of those shoulder cases. So this is a huge benefit to employers going forward. Part of the compromise to get this through the legislature was this new shoulder rehabilitation plan that they've put in. So as I said, shoulder cases, they were getting a heck of a lot of money for those cases, the injured workers were. So now the amount of money that they get in weekly benefits is capped at 400 weeks. But they've put in this new rehab benefit for people with shoulder cases that is totally separate from the old vocational rehabilitation, which was only 13 weeks for $100 a week. So it was a very small, sort of meaningless rehabilitation. So under this new shoulder rehabilitation plan, if you have a shoulder case, it's been decided or it's been agreed upon, then they can get up to $15,000 for tuition at a community college for retraining. Okay, this is huge. This is something totally new and different in our work comp statute, and it was strictly done as a compromise to get shoulder cases controlled. So the employer has some control over this as far as they have rights to get reports from the school to show that they are attending and successfully completing it. And as long as they are, they can get up to $15,000 in tuition and costs covered. Okay, another huge, a couple of different things. This is industrial disability, like I mentioned, is a body as a whole, where the commission looks at how does the injury affect their ability to earn for the rest of their life, and it can be very expensive. So in the past, an older worker, say someone who's 60 and has a back injury, would end up getting a higher award than someone who's 45 and has a back injury. Because the way that the commission looked at it is, how likely is a 60-year-old with a back injury to be able to get hired? Okay, so it's harder for them to get hired than somebody who's 45. So they would end up getting a higher award, which seemed counterintuitive to me over the years. So under this new rule, the commission is supposed to look at, Well, if they're 60, they were probably only going to work another 5 to 10 years. And so it sort of caps it or controls that. And this is something new, and it's changing the way that they're looking at these older worker cases. So instead of an older worker going in and getting an award of 60%, which might be hundreds of thousands of dollars, the older worker would be more likely to go in and get 10 or 20%, so the amount reflects more accurately how much longer they were actually going to work. Okay, this is huge, and this is something that you as employers need to be thinking about in how you approach these cases. So if somebody has an injury and it's an industrial disability injury, so it's to the body as a whole, which means anywhere in the back, torso, neck, head, shoulders, and hips, or emotional, that's an industrial disability claim. So in the past, those people got more than just the doctor's impairment rating. They got, as I said, whatever the commission thought was their reduction in earning capacity going forward. So those cases are expensive because they get awarded a much higher percentage and even permanent total potentially. So under this new rule, if you as the employer have somebody who has, say, a back injury, and they get a rating from the doctor, and you bring them back to work at their same position or at a position earning as much as they were earning before, at least, or if you offer them a position that fits within their restrictions that earns as much as they earned before, then they are limited to just that doctor's rating. Okay, so they have a 10% rating to the body as a whole for their back, and they have some restrictions. You pay that 10% rating, which is 50 weeks of benefits. You bring them back to work, and they're not entitled to any more than that. They're not entitled to recover for loss of earning capacity because you've put them back to work. Makes sense, right? Now, the caveat to this is if they return to work with you and you only pay that functional rating because you've offered them a position and they're working for you, if at some point in the future they leave that employment and it doesn't the language doesn't require that you've fired them or anything like that. If they leave employment for any reason after that, they can reopen the case. And at that point, they can go back and ask for industrial disability from the commission. There is no time limit on this, so I don't know if that means 6 years later they get fired for stealing. They can still open the case. That's what it appears to read to mean right now. That's something that we're going to have to see how that plays out through the system. Okay, I'm going to skip some of this because I don't have a lot of time. One change here is there are two different types of benefits that you can receive once you've had your injury, you've gone all the way through rehabilitation, and you're at maximum medical improvement. You can get permanent partial disability, which means like you're getting 20% award, or you can get permanent total disability, which, as I mentioned, means lifetime benefits. Well, in the past, there was this case that came out a couple years ago that said that you could earn both at the same time. Well, that doesn't really make any sense. If you're permanently and totally disabled, you should just get it once. So there was double dipping allowed. So under this new rule, you can't. If you're getting permanent total disability, that's all you get. You can't double up. Oh, and also you cannot get permanent total disability in any week that you're working and earning at least 50% of the statewide average weekly wage. And you can't get it if you're receiving unemployment benefits. So some of this was to prevent some of the double dipping that's been going on in the last few years. Okay, I'm going to skip that. Okay, so here's one thing that, that we deal with sometimes. I don't know if you as employers deal with it as much as your carriers deal with it, but an employee is required to submit to an examination if they bring a workers' compensation case. The employer can say, you need to be seen by such and such doctor on such and such date, and they're supposed to go see that doctor. And if they refuse to go in for treatment or an evaluation, then their benefits, their weekly benefits, were suspended while they were refusing to go to that doctor's appointment. And in the past, it was only a suspension, and if they decide a few weeks later, oh, I changed my mind, I'll go ahead and go to the doctor, then you'd have to go back and pay those weeks. Under the new rule, if they refuse to go to an appointment that you've set up, then their benefits are not just suspended, but they're forfeited. So even if they change their mind later, it puts a little teeth in that penalty, and it requires them to go when you've set up an appointment. Okay, here's perhaps the other big issue that came out, and that is interest. So in the past, workers' compensation claims have been paid at 10% interest. It's been that way for, I think, a couple of decades at least. And it's interesting because at the time that the statute was put in place, 10% was considered low because it was during that period of time when we were having 17, 18% interest, which was kind of crazy. So they locked in this 10%, which has stayed the rule for a long time. Well, now, if you get a judgment in a civil court case, the interest rate on that is just the T-bill rate plus 2%. So it's significantly lower. It's usually like 2.8%, something like that. So on workers' compensation cases, we've been paying much higher interest. So if you have disputed a claim, you've gone all the way through hearing, and the commission says, yes, you owe it, and you have to go back for the last 2 years and pay interest at 10%, those interest awards got to be pretty darn big. So this has been pushed for several years. It finally went through this year, and it has changed it so that it matches up with the civil case interest rate. So it's the T-bill plus 2%. So it makes it the same for all judgments in Iowa, work comp and civil cases. So what are some things that you should do as employers based on some of these changes? Make sure your people that oversee them within your organization are aware of these changes. Make sure your claims administrator, if you're working with a TPA or an insurer, also are aware of it. Because a lot of times you have an insurance company that covers multiple jurisdictions, multiple states. Make sure your folks that are handling your Iowa claims are aware of it. And then review your return to work policies to maximize the benefit from these changes. And by that I mean, maybe in the past you haven't pushed to bring people back after an injury. But it's really going to be helpful as far as controlling the cost that you have to pay out on these claims if you can bring those folks back to work, offer them a position. I understand you don't want to do a make work position that has no value to the company for any long-term basis. So you want it to be a meaningful position that actually adds some value to the company. But you need to change the mindset a little bit to, if possible, we need to bring them back. Because then you just pay that functional rating. You're not going to get hit with these perm totals or these 80% awards, and you're going to just be paying out the doctor's rating. And then it's going to significantly reduce the amount that you're going to have to pay out on these claims.